with Professor Giacomo Di Federico, who is teaching European law at Department of Law of the University of Bologna. Thank you very much for joining us, and the floor is yours.
Thank you very much. Thank you for the invitation, which I accepted gladly, because it allows me to talk about basically the results of my ongoing research on how digitalization has affected EU law, and in particular in the field of health. Now, let me start by making some preliminary remarks and some caveats. First of all, digitalization, the digitalization process has gained momentum, and it has been doing so for quite some time now. I would say the past 7 years have been particularly indicative of the effort it has been done at the supranational level in this regard. Secondly, artificial intelligence has developed enormously in recent times, and I would add in a non-regulated environment, at least up to now. And the references, of course, to the proposal on regulation on artificial intelligence. Now, of course, when we talk about artificial intelligence and health, the first thing I think that comes to mind is its use in diagnosis. I will not focus on this today. I will come back to this at the end of my brief presentation, but I will be mostly focusing on the major trajectories that we can observe looking at EU law and e-health and artificial intelligence. Thirdly, let me be clear, I will not dwell upon the numerous binding and soft law acts regarding e-health, ML health instruments, for instance, or apps, and on the specific issue of artificial intelligence. Now, to begin with, I have to briefly consider and remind the public of the limited competences that the EU enjoys in the field of health. And to begin with, I would recall Article 168, paragraph 7 of the Treaty on the Functioning of the European Union, according to which member states retain their responsibilities in the financing, administration, handling of the national healthcare system. That is an area where theoretically, and let me stress theoretically, the EU cannot intervene. On the other side, however, we have Article 168, paragraph 1 of the Treaty on the Functioning of the European Union, that sets a very clear objective, which is ensuring the highest possible protection of health in every domain covered by EU law. It's a transversal objective, and that we see in Article 90U, Treaty on the European Union. But this is not only a matter of policy, so pursuing an objective through policies. This is also a matter of defending fundamental rights. And in fact, the same expression, trying to guarantee a high level of protection of health, we find it in Article 35 of the Charter of Fundamental Rights. So this is the, let's say, the value-oriented dimension. Article 168, moreover, recognizes in the Union the proper level to try to ensure complementarity between the various national healthcare systems. Now, in order to do so, it is called upon to sustain, to coordinate the action of the member states. So in this field, and here I come to the limits, the Union cannot harmonize national legislation. It can only support the member states. So a lot depends on how much the member states are willing to concede. But there are, however, areas, and this is linked to the internal market, the functioning of the internal market, there are areas in which the EU institutions can actually harmonize. And this is intended to ensure certain quality standards and in particular for pharmaceutical products and for medical devices. And here I come back to the internal market logic, of course, because we are basically dealing with goods, and we have to ensure that goods can circulate freely within the internal market. And therefore, we understand why the EU should be entitled to harmonize and why the member states have recognized this power to the EU. This is specific for health, but if we look at constitutional law in a comparative perspective, we find that everywhere we have an attempt to divide competences between the central level and the decentralized level, we will find it difficult to isolate fields. And this is the case also for the European Union. As you know, there are three kinds of competences: exclusive competences of the Union, shared competences of the Union, and parallel competences. So here we are in the shared domain. And just to give you an idea of how there can be overlapping between internal market issues and health care issues, suffice it to remember here the directive on tobacco, which of course deals with the, has to do with the protection of health, but it also has to deal with the free movement of goods. Now, if I look at the combination between possible combination between Article 168 and Article 114, there I understand that there is great potential in the use of this dual legal basis. And just to offer you an example, the most outstanding example, I would say, is Directive 24 of 2011, recognizing patients' rights. And here, what the EU legislator has done, it has harmonized a number of procedures at a national level for authorizing patients to be cared, to be taken care of and cured abroad, and also in terms of reimbursement of the expenses connected to the treatment. But what is interesting is the second part of the directive, where the EU legislator tackles some transversal issues that are more related to our topic today. And in particular, it sets up an e-health network. So a network bringing together those agencies that at a national level work with digital health. Now, this has allowed an enormous development in the recent years, and I will come back to this in just a second, but just to be clear, I'm making reference to medical records and to e-prescriptions. What I would like to stress in particular is what I call the pandemic boost to the de facto transfer of sovereignty in healthcare related matters to the EU. Now, if we look at the takeaways from COVID-19, what we see is more involvement of the private world, producers, developers, in the handling of public health issues. I'm looking at involvement in standardization bodies, but also in international fora, discussing how to orient the choices of the legislator. Secondly, there is more use of digital instruments in various areas of health or connected to health. There is more use of artificial intelligence. And therefore, this generates the need to regulate its implementation in compliance with the founding values of the Union on one side, and on the other hand, with the fundamental rights enshrined in the Charter. Now, this, of course, raises a number of ethical issues which are addressed in the proposal for regulation on artificial intelligence. So if this is the case, what is the state of the art? And here I would like just to formulate some brief considerations on the, well, let's say some post-pandemic considerations. Firstly, if we look at those major trajectories, which I referred to at the beginning of my speech, well, firstly, we look at we can observe the creation of a number of networks. One I've already mentioned, the eHealth network, networks of experts, panels of experts, groups of experts, all devoted to promote mainly the interoperability and the portability of data in the field of health and in a safe and secure environment. This is, of course, referenced to cybersecurity, but also, of course, to the GDPR. When you exchange health data is by definition personal data, and therefore these are the issues which automatically arise. Now, I have to say that interoperability and portability of data is, I would say, a mantra of the new approach in the field of health. Reforms which have been put forward recently all include a reference to new technologies and to the need to develop these new technologies, still guaranteeing interoperability. So the idea is to favor development, but at the same time, make sure that the various developments can be brought to a synthesis, because if not, we're just dispersing resources and energies. Secondly, we can observe the affirmation and development of digital infrastructures. Now, this is, we can single out three levels. The first level is patients. So you have digital infrastructures to favor the protection of patients' rights. And so here, the first most notable example is the EHDSI, eHealth Digital Service Infrastructure, which allows the exchange of health records and e-prescriptions. And we are looking at 2025 to see actually the wide implementation of health records and exchange of health records. There is also a big focus on surveillance. So not only patient rights, but for surveillance purposes. And this here, of course, I go back to the takeaways of COVID-19. And so here, before COVID, we had the European surveillance system, TESI, also known as TESI. And this is for the exchange of surveillance data between national competent authorities and the Commission. If we look at the new regulation, which will be repealing Decision 1082 of 2013 on the management of cross-border health threats, serious cross-border health threats, we find out that the idea is to develop a digital surveillance platform, which will be useful for planning, capacity building, and research in cases of emergencies. And what I found interesting here is using artificial intelligence systems to monitor media, so to confirm the data coming from the surveillance network, here again another network, and more specific networks, and also the network of EU labs working throughout the territory of the member states. Now here, the European Center for Disease Prevention and Control, the ECDC, has been entrusted with the task of promoting technological advancement and also using technologies in order to fight disinformation. And this I also found very interesting because, again, it's a link between the technical aspect and the aspect related to the protection of values. Democracy, for instance. Thirdly, so apart from patients and surveillance, platforms have been developed to foster research and innovation. And here again, a lot is to be a lot has to do with the experience we developed during the pandemic. And so here I cannot but mention the European COVID-19 data platform, which enables a rapid collection and comprehensive data sharing of the available research data from different sources at the European and international level. Now, the idea here is to arrive to the creation of a European open space cloud. And this again should allow, let me get back to one of the points I raised before, it should allow also the public and private sphere to work together. Now, let me turn to the legal, political, and ethical challenges ahead. What I just tried to represent very briefly is extremely positive in terms of cooperation and coordination, efficiency and effectiveness in dealing with health emergencies. It does raise a number of problems, legal problems, in terms of competences. As you know, the European Union is guided by the principle of conferral. So the EU can intervene only there where the member states have recognized this right. And if I look at the new legislation adopted in the aftermath of the pandemic, what I can note is that there are cases in which the system tends to be uniformized more than harmonized, and this creates a problem with respect to fields which fall within parallel competences, where, as I said, you cannot harmonize. But here again, this tells us how political the principle of conferral is, because here the member states have indeed accepted that the EU represents an added value. And here, this allows me to turn to my second point. If we look at the future, we look at the results of the Conference on the Future of Europe, what appears clearly is that governments and citizens have understood this added value. And I think this legitimizes in some way the transfer of more sovereignty to the EU level. This is what is called the federative ongoing process in the field of health. Now, of course, this raises a number of issues, because transferring more power to the EU means transferring also very delicate aspects. Amongst these aspects, artificial intelligence, and in particular, this raises the question of what and how much we can entrust to artificial intelligence systems, which of course also depends on technological advancement. And now let me get back as a final point I wanted to make. Let me get back to the idea of creating a true European health data research space, which is one of the components of the European Union, the European Health Union. Now, if we look at the proposal presented by the Commission in May 2022, so just a few months ago, on the health data space, we find that here the idea is to create a common space where natural persons can easily control their electronic health data, but also, and we go back to the involvement of the private sphere, it allows researchers, innovators, but also on the public side, policymakers, to use electronic health data in a trusted and secure way, as I said before, and that preserves privacy. This, it is interesting, this idea builds upon the directive I mentioned before, 24 of 2001, which is the first piece of legislation recognizing expressly the importance of e-health in dealing with public health matters. The proposal, in a nutshell, aims to ensure a legal framework consisting of trusted EU and member states governance mechanisms, and a secure processing environment. Secondly, natural persons in the EU should have increased control in practice over their electronic health data. On the other side, researchers, innovators, policymakers, as I said, and regulators, of course, both at the EU and national level, should have access to the relevant electronic data to promote, and here I come back to where I started, better diagnosis, treatment and well-being, and more well-informed policies. So here you get the added value of e-health and artificial intelligence instruments, both at the private level and at the public level. The idea is, at the end of the day, to create a genuine, and I'm quoting, single market for digital health products and services by harmonizing rules and so boost healthcare system efficiencies. And there I will stop, but of course, if there are any questions, I'll be happy to take them. Thank you very much.
Thank you very much to you, Professor Di Federico. Thanks a lot for this very important overview and comprehensive picture of the EU law system about Earth. And as we did in the last panel, maybe we can have all the presentation and then we can collect questions for the debate, or maybe you need to rush and
unfortunately,
okay.
I have an appointment at 12:30,
okay, no problem.
which I can't miss. I'm sorry.
We can open the debate and we can collect some questions. Okay, so please, either from remote or from here, if you have any question, I can the micro. Please, I can bring the micro.
Thank you, Professor Federico. Di Federico, I'm Richard Ruck. I would like to ask whether you see any contradictions within the European health data space proposal between strengthening, shall I come closer? Between strengthening patients' control over their personal data with against the other consideration of ensuring access to these data for the purpose of secondary use. Because there are many people in the room related to Italy and Spain, for instance, and I know that in Italy it is very challenging to access and share patients' data by health professionals. Whereas in Spain, it's doctors have access to all patients' data who are under their treatment. So there seems to be a contradiction, and the European health data space proposal seems to favor the Italian position in this regard. So do you see any contradiction within the proposal? And also whether this standpoint of favoring one member states, in the present case, the Italian position over the Spanish position, would have any consequences. I don't know about the other 25 member states, but I'm sure there's some kind of division, and this might lead to conflict between member states, so on which legal position this proposal favors.
Yes, thank you. That's a great question, I have to say. I think we have to understand that at the EU level, you try a synthesis, you try to frame legal rules so that everybody can try to follow them to a certain extent, especially when we're dealing with these delicate issues. A lot has to do on the, of course, interpretation of the GDPR and the standards of the applicable standards. As we know, there are different approaches by DPAs And that is that really affects the uniform application of EU law. Now, above and beyond the legal issue, and so which is a matter of interpretation by the DPAs, and the Italian DPA is particularly restrictive, I have to say, also when you look at the use of health data for research purposes more than in other countries. So there is quite a restrictive approach that can depend certainly on a legal interpretation, which is normally the result of a cultural approach. But on the other side, we have to keep in mind the technological aspect. If I look at the exchange of medical records and e-prescriptions, what I see is that there are many new member states who have advanced in digitalization, have shared protocols, have shared semantic rules, and have been able to implement these technologies with no major difficulty. If I look at some old member states, and amongst them I have to include Italy and Spain, this presents a little bit more difficulty. But again, I think that it is a matter of just catching up with our times and realizing that at a certain point, the added value, and here probably I get to answer your question, or at least I hope, the added value of sharing data in the field of health, not only for personal reasons, so for the patients, but also for surveillance reason and for research reasons in the common interest, that I think calls for possible limitations of the, well, I wouldn't say possible, sorry, take it back, not limitation to privacy, but a different understanding of the value that health data has, which allows us to accept more risks. This is why every time we talk about, if we look at the legislation, every time we find a reference to privacy or the fundamental rights aspect, we also find a reference to safety and security of the platforms involved. So, and that is the public responsibility. I hope I've answered your, or at least addressed your concerns.
Thank you very much. Maybe there are some more questions.
Thank you, Professor, for your presentation. Do you think that the European Health Data Space proposal needs for a regulation on replacing and like repealing Directive 24, because the right of access to the electronic health records is granted in Article 14 of this directive, but then we have also the right of access of the GDPR, Article 15, and the national right of access to healthcare and to digitalization in healthcare. So do you need that there should be a regulation to harmonize, as you say, this new competence of the EU in this matter?
Thank you. This is also a very good question. I think the time has come. We have already reformed other provisions, or at least Article 15 of the directive has been already amended. There's a law going on. We have evaluation on health technologies. There are a number of interventions now that I think called for a major rethinking of the directive. It was a very ambitious directive, so much so that the Commission started infringement proceedings, I think, against 26 out of 28 member states. So that already tells you that it's controversial to the extent that it does impinge. This is my position. It does impinge on the administration, on the managing of healthcare systems. That is to me pretty clear. What is clear to me and what calls for a reform, I think that now member states are more willing to share resources and concede that the EU has an added value. So I don't know how you could frame it without formally violating the principle of conferral, but I do agree that we should start thinking about it. If I look at the health package presented by the Commission in November 2020, as I said, it uniformizes more than harmonizes. So that is already to me quite surprising. So yes, I think there is the political momentum. I don't know how it could be framed legally, but it's certainly very stimulating to think that way.
Thank you very much. Are there some other questions? Yeah, please.
Thank you, Professor. Carlos Gorrit from Autonomous University of Barcelona. I just was thinking whether we need more laws on this field. I mean, we have seen that in the previous interventions that lots of new European laws are being applied. You are talking about the digital health market, and I find it perfect. We need one of these markets, but I don't know if we need so many laws, because European enterprises seem to be overloaded of bureaucracy. And one of the main principles in company law, in European company law, is to reduce the bureaucratic load the companies are suffering. Thank you.
Okay. Okay, now it's quite interesting to note that you mentioned EU legislation. Now we're not talking so much about regulations and directives and decisions anymore. We're talking about acts, which are normally regulations. I find that interesting in itself, because it is giving the idea of an EU more accessible. You talk about acts and you don't get into the detail of whether it's a regulation, directive, or a decision, which is basically irrelevant for citizens. But one of the major, I understand your concern, especially coming from a commercial law perspective. Absolutely. But we are abandoning order liberalism, I'm afraid, and we have done so for quite a while now at the EU level. I understand, again, your concerns. I share them to a certain extent, but I also would like to insist on legal preparedness. The pandemic has taught us that we have to be ready from a legal standpoint. We need also to protect our values, we need to have legal basis that legitimize the intervention of institutions, bodies, entities, agencies in their various forms. So I think law is in this moment important to set the boundaries of what we can do and what we cannot do during emergencies, having in mind, of course, the protection of fundamental rights on the one side, and on the other side, the development of technologies. And you can't constrain them too much, because if not, you won't create the incentive to develop these technologies. I think we have to find, this is a moment in which I agree we're trying to regulate. I don't know whether we are at that point of over-regulating, but the issue you pose is a serious issue. And at some point, let's say when the dust settles down after the emergency we're facing, we will have to think about simplification as well. I will stop here.
Yeah, thank you very much for your intervention. We would like to thank you again. Thank you very much.